Hello, good morning, or good afternoon. Okay, just about on the cusp of change. You all know Honda company, motorcycle cars, everyone uses. Okay, Honda company was started in 1946, and if you recall our old movies, there was a Hindi song "Mera Juta Hai Japani." Okay, you all maybe some of you may be knowing this. So that was the actually quality of Japanese products as perceived in 1945 or 46. Today, in the automotive industry, the largest patents, number of patents, only Honda has. Okay, and so that's the mission with which Honda has worked. In fact, the Honda family only owns the R&D center of Honda. So all other car manufacturing is completely independent. So that is the potential, or that is the crux of the thing is that there is a potential. One is, of course, you can encourage that potential. I don't know how many patents Honda company has, and the way they are creating models after models, innovations after innovations, and the family only owns that. And that is something which talks about the not just commercial potential. That's the potential of your research work. So, with this little bit of background, I'll be requesting all of you to add few things. So, Nilesh sir, I just want to start with you on this whole journey of patents. Where does actually India stand? And that is something which I thought we should start with that.
Uh, it's a very pathetic story. If we see globally, the China applies almost 12 lakh patents and gets 4 lakh patents, and India applies, let's say, around 45,000 patents and get 12,000 patents. This was a story 4 years back. This year we have granted almost 28,000 patents. And what the scope? We are leading in IT. We are really great innovators. I can see a lot of innovation hubs across India, but we don't file the patents. We just shy away. We are hesitated to do it. Why this is happening? There may be the scenarios, there may be a problems, but we don't want to go for that examination of getting patented. And getting patented is the scenario, is the pain point which every innovator has shared with me. So what I see globally, US doing great patenting work, Japan doing great patenting work. 1965, the Japan started doing more research and doing more of a patenting. Similar story with your shoes, and their GDP grown with number of patents filed by them. 95, I was arguing with my Chinese colleagues in London that we are a software country, we are doing so much in software, we'll earn dollars. And the guy was trying to tell me, Nilesh, we are doing all basic work, we are more into the product research and product patenting. I see in last 25 years, their GDP has gone like hockey stick, and we are still there. So they choose the right path for manufacturing, and more of manufacturing, patenting the technology. When I was in Africa, I was trying to buy out one patented technology product from US costing around 20 lakh rupees. Similar product with Chinese patented technology was available 4 lakh rupee. And India, I could not find a single company with that patent. I could not afford, being Indian, to buy that product which was manufactured amply in India. So this is where you can see where the Indians are losing on globally. I think that is a pain point I can share with you.
Yeah, but you are saying it's a very grim situation. But is it because people are not aware of process, or is it because generally that people are aware of process but they don't want to take it?
So the real problem is patent time. The process time takes sometimes 2 years, sometimes 5 years, and the manufacturer wants to sell it tomorrow. So what we need to really plan is a long horizon. I can plan out my products for 3 years down the line. Like if you release the software, you always talk about app 1.0, but you should start patenting your app 3.0. So the 2 years down the line, when your app is ready to go to the market, your app is already in patenting. So you have a patent and you are talking about the patenting technology, or maybe your machine which is going to be released in 2 years time over the development period. You can start patenting that, because when a couple of years back when we were talking about 5G, all 5G modems and 5G equipments were developed 7 years back, and that Ericsson was filing all the patents. So we know that what technology will come in next 5 years time or 7 years time if we see the WIPO's website. So I think it is a time planning we need to do more.
Okay, good. I think that is. See, we have a center here. It's called Center for Industry 4. So we developed something called Smart 50, and this is like a proprietary tool. Okay. Now, till recently, we didn't know that all the laws of copyright, patent, and documentation, all that. I mean, I'm also like all of you. Okay, let me say that. Admit that. So one day on LinkedIn, somebody posted this as his own creation. Okay, and typical Punekar. So he came to our center. He took a picture, and we do allow people to take pictures. So and he posted on LinkedIn. I got a call from our funding agency that there is something, someone is claiming that it's his own. Have you taken any measures on this? So I didn't know that because I'm not as active on LinkedIn as my colleagues are. That's another problem. So then we found out. So we found that this person or entity was just across Chaturshungi. So he had come to our center maybe 3-4 months ago, and then he took a picture, and then he created a very nice image of that. Then I started actually, we called him, of course, we took some penalized action, that's a different story. But then we started searching for what are the documentation required, what is the process. Then we sought some guidance on that. So, Dr. Khedka, I just want to ask you, purely from a documentation or the process itself, if you could throw some light on this.
Yeah.
I've gone through personally a very big challenge.
Okay. Prior to that, I want to add a little bit what Nilesh sir has said, or you had asked earlier that why we Indians are so bad in doing patenting. So, does it mean that we are not good at really doing research? No, we are very good. But then why the figures are not indicating as far as patents are concerned? So there are probably 2-3 things. One is related to our culture. We have hundreds and thousands of years ago, we were in Gurukul Paddhati, where the education was supposed to be given free of cost. So we have still a mentality, if I have invented or if I have created something, why should I own the rights to me individually? Why should I not give it to the world free of cost? This is probably one of the psychological drawback of us. I'll not say drawback, but this is one of the fact which decides whether to go for patent or not. Yeah, upbringing. And the second part is, to some extent, we have got little inferiority complex also. मैंने क्या खास किया यार? When I meet my clients, most of the time my clients, they themselves say कि नहीं, whatever we have done it, it's not patentable. I ask them, do you understand what is patentable? No, we don't know. But नहीं, हमने कुछ अच्छा खास नहीं किया. I'm sorry to add a little bit of Hindi and Marathi mixture because I can express more fluently that way. So नहीं, हमने कुछ खास किया नहीं है. Then I said, यार, why are you paying me for telling me that you have not done anything? You are paying me, so let me decide whether you have really done or not. So to give you a couple of examples, we all have seen safety pins. Normally women's use for their pallu and odni. Do we have any idea how many patents there may be on safety pins? Can anybody guess? No idea. Anyway, it's the simplest product we have ever seen probably. There are close to 200 patents. Some of them are design patents, some of them are utility patents. So my suggestion to you is, if you are working on any product which is a bit more complicated or a bit more bigger than a safety pin, please consider IPR. This is how only our numbers can increase.
Great.
Okay. Now your question was about related to documentation. Yeah. Um, Regarding documentation, I'll talk more on patents, on not on other parts of the IPR. Regarding documentation, the first thing you should start do is keep an inventor's logbook. There's a logbook which should be ideally a hardbound logbook. Okay, prior to that, I should explain you one more concept of inventing. In worldwide, it was earlier patent was given to first to invent. Nowadays, it is being given to first to file. Try to understand, if Nilesh sir has invented in 2010, but he has gone to patent office in 2022, and I have invented in 2018, 8 years later than him, but I have gone in 2020, I'll be given the patent and he will not get the patent. So the first concept is first to file is being given in importance. So for that, whenever you get an idea, you should try to evaluate and first run to the patent office for filing. Now, when it was first to file earlier, that time the importance of inventor's logbook was much more, because it was a legal document earlier, where you were supposed to put your ideas and you were supposed to keep notes as your idea is growing. And those notes, all notes were supposed to be dated. Now it's no more that important, but still, documentation will still help even in the first to file era. This inventor's logbook will help you to know and understand how your invention is growing over a period of time. Sometimes the invention may take couple of seconds to grow. Sometimes it may take couple of years also. Sometimes you may have to keep on experimenting for years and years before you really arrive at the idea. But sometimes it may be just an overnight expression also. So please make it a practice of keeping inventor's logbook. Keep notes right from the problem statement to how you arrive at some idea, then what you may do, certain experimentation, you may do certain prototyping. Keep on recording those results into that. The best part of all this thing is you will enjoy the journey of inventing. When you look back couple of years earlier, you'll see, how was I 4 years ago and where am I today? Those notes will help you a lot. And please put the record in terms of date, place, and if you have any witness to witness that work you have done, keep a record of that in a hardbound inventor's logbook, and those pages should be numbered. So that is how you can keep the documentation. I hope I have answered, sir.
Yeah, I think one thing we all engineers or science students, we like to experiment quite a lot, but the documentation is something which we are very weak. Even when we were student, I can say that very few people used to make notes, because that shows the mindset that because we are trained that we think that our memory is like ultimate. And that I think we have to be really careful.
A common mistake.
We make a common, and but this documentation process, and I think that's a very valid point. If we can create some kind of a
If you
logbook.
can elaborate more on how to search for a patent when you want to do the prior art kind of thing. Many people have filed the patent, so they may be known the terminology called prior art. But I think you can throw some light on it.
Yeah. When I started my journey of inventions in 90s, I used to search patents through hard copies. I used to go to Mumbai Patent Office and search through their library.
Why do you want to search the patent?
Okay. The intention is that I am not reinventing the wheel. Many a times when I come up with a new idea, or rather I'll say 99.9% of the time, you will find that somebody else has already worked in that idea. See, I'm quoting it again. 99.9% of the time, you will find that somebody has already worked in that idea. Now, what to do as an inventor? See, whatever I think, I find somebody has already worked it. The real challenge to inventors starts here. When you find that somebody has already worked on your idea, you will find it's not only one person who has worked on that idea, hundreds of people might have worked on those ideas. The reason of searching those patents is to know where the world is today and start finding the gaps between whatever they have already invented. See, as an inventor, what we do, we find certain problems in society, certain problems in business, certain problems maybe faced by the disabled people, maybe faced by the women, maybe faced by the kids, or road driving or anything, road safety. And there are many things we find those problems and we try to find solutions out of those problems. As an inventor, when I'll study the patents, it's one of the richest database of knowledge in the world. I'm telling you, whatever products we see in the world, we find certain problems out of that and we end up finding a solution. But the knowledge base available in patent database, only 1% of that knowledge base is visible to us with my naked eyes. 99% of the knowledge base is still there in those patent libraries. So to get access to that knowledge base, and before I start reinventing the wheel, I should study all those patents. And you give one keyword and you will find hundreds and thousands of patents falling in line with you. Now, your generation is so lucky that you have everything available at your fingertips right here. So please utilize it properly. And you guys are so lucky that this is now available even on paid databases. On free databases. When I started online, it was available only on paid databases. Now it's available on free databases also. You can simply go for Google Patents. You can search on freepatentsonline.com, uspto.gov, then WIPO, World Intellectual Property Organization, also has got search engines. So don't go for pure Google search. Go for Google patent search. Google search is very, very limited. Google patent search is better. I'll recommend go for freepatentsonline.com or uspto.gov. These are even better search engines. And you all kids are so smart that I don't have to tell you about how to search further. But please search more, please study more, please understand more. You will see a different world which is right now not visible to you with your eyes. Thank you, sir.
That's good. So, Ashna, moving to you, some basic fundamental part first. Can you elaborate a little bit on patent, copyright, and trademark? Okay, so just to starting point.
Yeah.
So, what applies where?
So IP is basically consisting of anything that's a property which you can't really touch or see with your naked eye till it's actually manifested into something. A copyright is an idea that you've put on paper. It could be a story, it could be a poetry, it could be a software code, it could be anything that you write, express, sing, or record in any manner. Trademarks are basically used as special markers to indicate the organization or entity from which a particular property is coming. McDonald's, the minute I say that, you think of a burger. I say Wagoner, you know which brand it's coming from. It's coming with a lot of goodwill, it's coming with a lot of assurity of the entity that's backing it. Now, when you come to patents, there is a big question mark in people's minds about what exactly is it. I know it's an invention, but what is it? It could be a part of a car. It could be a different way of making a spoon. It could be a comb. It could be a safety pin. It could be a process. It could be a method. So if you find a way of making something that is unique in terms of a product that you touch, it's a patent. If you find a new way of making a process, it's a patent. There is no end to what you can do with a patent and with an invention. As far as identifying these three are concerned, it is my personal experience that people are very well aware of copyrights, because when we are accessing the internet, a lot of times you see things saying that this has been copyrighted with a C and you see a ban. We are all aware of trademarks because we see them on billboards, we see them on things we eat, we see them on things we touch. But when it comes to a patent, it is very difficult to identify that, oh, even this has been patented. This bottle in front of me has been patented. I don't think anyone waited for a moment to think that even this could be patented. So, because it is not so well advertised, there is a lot of, I would say, lack of awareness among the public about what a patent is. And I feel as students, it is our job to take that first step to understanding what all can be patented, what is new, and there are a plethora of opportunities out there as students, because sometimes something very small might come to your mind, which you might think is a silly idea, but that's how a lot of organizations have started enterprises which have made millions today. So I think it's all about reading, understanding, and giving yourself a chance to explore that world.
That's nice. Yeah, thank you. But now, when we start applying for a patent, let's come to that. Is there some kind of a checklist you suggest, or some process you would like to?
Yes. So most times, as researchers and inventors, the biggest problem that comes with pushing it in the direction of patenting your invention is you shy away from documentation. But let me tell you, a patent is not something that you're doing alone. You will have an entire team behind you without knowing. You'll just end up building this little system for yourselves, which will help you in getting there. Some of the people are your mentors. They are going to play a very important role in guiding your invention, and also your lawyer. So whenever you want to start and you've reached a point where you feel you've done your patentability search, you finally narrowed down your invention, you have reached that point where you feel it's new, it's novel, and you want to patent it, the first thing I would recommend is make a patent checklist. So what is this checklist? It has two important parts. You explore yourself as the inventor, and you explore the invention that you have invented. So let's start with your invention. What are some of the points that you need to really write down about your invention? First thing is identifying the field of invention. A lot of times, you would think that your invention belongs to a particular field, but you would be surprised that that same invention can also have an application in a completely different field that you did not think of. Speak to your mentors, explore and read about it. Narrow down that invention to a particular field. You might find it is patentable in a different field altogether. Then comes keeping a track of a prior art. That is something only you can do for yourself. Read, and read. Like he said, use Google Patents, but also explore technical papers. A lot of it is non-patented literature, which might stop your invention from being patented. Make time to read every day. Read up about your invention. The third thing that you need to do after you found your prior art, after you found your field of invention, is really sit down and make a list of what are your advantages of this particular invention over what you see out there and over your prior arts. And also an important thing is the disadvantages, because sometimes that disadvantage is going to be your next patent. So it's very important to also find the pitfalls in your invention. So once you've covered all of this, the next step is to identify who you are as far as your invention is concerned. Are you an inventor? Are you also the applicant? Are you just the applicant? It's very important to identify your role with your invention. This is particularly important for startups because you could be the inventor and you could sell your invention to an investor who will then be the applicant. There are various laws that are in place which really help you as inventors. There are so many initiations taken by the government to help you with it. So you might have a less cumbersome and a less expensive process if you are a startup, because there are laws in place to help you with that. If you're a student, there are several laws that help you to not just reduce the cost but also increase the speed at which it will be examined and the rate at which you will get your patent granted. And I think another important aspect of starting your patent filing process after you've narrowed down all these things is to really study where you are as far as your invention is concerned. It is a misconception that you need to have everything figured out before you file the patent. You have something called as a provisional application. That is the main tool that a lot of inventors unfortunately are not using. If you feel you have made a prototype and you are currently at the point where you're still tweaking around with your invention, please file that provisional application. Speak to a lawyer, because you don't complete your entire invention there. So it gives you the date on which you file, and then you can take up to 12 months to decide where you want to go. Another reason why we also recommend provisional applications is because a lot of times you think you might not get investors, but you'd be surprised at who is coming forward to really back you up about your invention. If it is commercially viable, there are times when you might also get an investor who wants you to file it in multiple countries. So why close the door? If you file a provisional, you still have up to 12 months to take and the call to file it internationally using a PCT application. The advantage of doing that is you get up to 30 months to gather funds to really go ahead and enter the national phase in multiple countries. And it's not the first time I've seen where, unfortunately, the inventor does not have faith in his own invention. He files the specification and realizes 10, 12, 15 months down the line that, oh my God, I had a huge market in the US. This particular person was ready to back me up to take my invention there, and I did not file it. So give yourselves that time and use the tools at your expense. Speak to a lawyer. One key thing that I have realized in my process is, have you heard of minutes of a meeting? Usually your lawyer sends you the minutes of a meeting. I feel you shouldn't do that. Make your own minutes of the meeting. You know your invention the best. There are times when you feel, oh, this is just an aspect of the invention, but that's actually a novel part of your invention which you did not explain to the lawyer well. Write it down. Go back to him. Keep multiple versions of the documents you make. There are so many times when you just hit the backspace thinking, oh, that's not relevant. Don't do that. Please pen everything down. Because a lawyer and your mentor sometimes knows more things about your invention that you did not notice. I guess
I think
I
Sir,
would like to
just
cover it.
add on this.
Yeah.
What she explained is a technical language and techno-legal language. So when it comes for a techno-legal language, we need a lawyer to write that techno-legal language. As an inventor, we can really think of technical language, we can write lot of technical language, but the addition of lawyer make sure that you get a patent.
So, sir, just I want to, for my own understanding, and as well as what are different roles. So, one is a attorney, then there is a mentor or coach, like, and then there could be an agency who can guide. So, if you could elaborate a little bit on different roles that play in this
The
whole journey.
initial role is a innovator who is inventing it. The applicant can be the university, can be the college. Then it comes for a counselor who counsel with you and make you understand, yes, your innovation can get these claims in this gray area. Like sir said, there are 200 patents for safety pin, and I can think of 201 which nobody has claimed on. So what we get patent is for that claim. We can do 10 claims, we can do 20 claims, we can even do one claim. So the claim is where the counselor will help you to make you more understand that what is patentable, what is not patentable. That comes for more of an attorney who really files that document. So he writes all techno-legal language. He is not a technocrat, so don't make him understand what the software is, what the innovation is. But your logbook will help him to create a story of a sequence. On day 1, I visited this. On day 2, I reiki this. On day 3, this is what and a claim what you can do for your patent. So the more chances that you get a patent, and the last but one, you can hire any agencies to commercialize that patent. So monetization is what missed in the whole discussion. So you can think of monetizing your patent through a lot of online agencies, offline agencies. There are many marketplaces, those who can help you to monetize your patent. So these are the five terminologies or the areas you should be more aware about making money out of patent.
Yeah, that's nice. No, just extending this question, how you and Vego as a team, how it's mentoring different startups, or I mean,
So
and how they can reach out to you.
the first thing is a checklist. You can go on vigolibrary.com, click on contacts, you can download that form, and that form will give you around 20 odd questions which we have discussed here. This will make you prepare to apply for a patent or discuss with anyone. You can call us on our helpline number. We will allocate first the counselor to you who will make your research patentable. Then the counselor will hand over a case to the attorney. The attorney will create the papers for you, and they will file the patent and will sponsor the complete processing fees for you. We will handhold for 3 years with you so that you make sure that you get a patent. So it's a 3 years journey. What we will be with you like as a younger sister, and you have to gift me on every Bhai Beach a single patent.
That's nice. That's the best way to put it. Mr. Khedkar, I just want to moving on to this part. So, if we have decided to take up a research subject, and you explained that there is a search required, and there is also we have to differentiate between what is available and what is not available, and what I'm doing today. So, how do we match up all these three?
Okay. For that, we have to have detailed novelty assessment report, which preferably should be done by an expert. We probably may not be able to do it ourselves very well, but that doesn't mean that we should not do it ourselves. We should try to do that at a preliminary level. After having done that, probably we can approach to some professional consultant who can help you to understand and identify the technology gaps which are there. Like today only in the morning I was discussing with Nilesh sir. We were studying the patents related to e-waste recycling. You may not know, probably there are close to 10,000 plus patents on e-waste recycling alone. Right from how to recycle LCD display, how to recycle an LED display, how to recover the metal, how to recover the plastics. All in the last 30 years, approximately 10,000 patents have already gone into it. But still there are lots of gray areas in between. We have to understand those gray areas and plan our research in those gray areas. That will give us a lead that we will reach to a really patentable technology. Otherwise, if I just try to pick up my mobile and if I try to work on how will I recycle this mobile, probably I may come up with 10 ideas. Out of 10, 9 or probably all 10 are already patented. So we'll just end up wasting our efforts. So this is how you can go ahead. And there is a lot of information already available on internet. There are videos, there are research reports available. So please go through that. And I would like to add a little more other than this, especially to all those who are related to academics. Many of my clients, they come to me that we want to file a patent. And then after coming to me, they tell that we have successfully made a prototype and we have published it in so and so journal. By publishing it in any journal, you are ensuring that you will not get the patent. And those technocrats, those even professors tell, no, but it's done by me and it's published by me. Yes, it's done by you, it's published by you, and you have ensured that you will not get the patent. So, keeping secrecy of your idea is extremely important. And as Madam has said, if you want to disclose that idea with someone for say prototyping work also, first go and file the provisional application. Then disclose the idea to some people for prototyping or further research work or further guidance, consultancy and all that. Then go for complete your work and then file the complete specifications.
I think sir has suggested some sequence. Monday you file a patent, Tuesday you release in journal, and Thursday you claim everything with you. So it's a sequence. We file Monday journal, and then Tuesday we go to the patent office.
Yeah, and Nilesh sir, you had written a letter to UGC chairman. Why don't you tell that here?
Yes, I was discussing with Jagdish Kumar sir कि why should a professor have the PhD, and if he has a patent, why don't he get an associate professor or professor qualification? And we requested them that at least the patent owner can be qualified as additional qualification to existing qualification. So maybe we may see more patent owner as an associate professor or professors. They are already working on it. They assured me that they can create a committee and evaluate this suggestion.
In other words, holding patents may carry importance as much as maybe doing a PhD.
That's
Thank you, sir.
I think that's okay. Recently, I came to know IIT Delhi. They have put forth this as a suggestion to their academic council that even if you don't have a PhD but you have patents, you can become a professor par excellence, or some designation is there. But that I think IIT Delhi has taken that first step. Okay, but just want to. When we are in the process, are there some other documents with our where the ideas can get executed or produced, like non-disclosure agreements or such things are also can be useful?
Yeah. NDA will definitely help. In fact, there are a lot of agreements which you need to do before you start. Even after having filed your provisional application, you are still supposed to exercise or you are still supposed to ensure that the information remains confidential, at least till it is complete specifications are filed. So there are many things like non-disclosure agreements you can file. You can have other confidentiality agreements with people. And here I can also touch a little bit about trade secrets part. There is a lot of information which we create during our research, which may not be really patentable, but which may still be relevant to a particular industry, which may still be relevant to successful completion of any business. That information can be protected under trade secrets. We will not discuss much about trade secrets here, but a simple thing like list of students is also an IPR which is worth protecting. Or maybe list of clients, list of patients going to a dentist is also worth protecting. It has got a lot of commercial implications. It doesn't fall under patent. It falls under trade secrets. So try to understand the trade secret law also. As you proceed on your journey of invention, you'll be able to protect your information properly. Thank you, sir.
Is there some kind of a structured course program just to educate, since you are also dealing with UGC, is there any at a university level or?
There are many programs. You just Google search, enroll any program in 3 months time. You will know everything in IP. But here we all are startups. We have worked on certain things. Do anyone know how the valuation of startup is done? Have we done any the course or any discussion on that? So since morning you have been understanding valuation for startup. Have anyone asked if the patent is added, what kind of valuation extra I will get? Okay, so I will just bring to your notice what the investor is looking for. I am a serial investor in startups. More than 16 startups I have invested. Amount varies differently. But if I look for a startup, what I look for is a secret sauce. A secret sauce which is valuable. If there is a value in it, how I can protect that secret sauce or that value by a trade secret. So you can look for a trade secret laws and you can file the trade secret under the patent. With patent, what you will really build is the core assets. So you have bundle of assets. The patent will be one more adding asset to it. Secondly, the investor what looks for is a long-term recommend-worthy product, or maybe prover by a competitive, sustainable advantage. So these are the terminologies we hear. But try and understand, if my valuation is, let's say, 9 crore on an angel, and if I invest, let's say, 3 crore in that company, in 2 years' time, they have a runway. And if they can get the patent for their research or for their product, what I'm going to get at Series A, I may look for 30 crore valuation, and that additional 10 crore come from the patent itself. So you will create a value for an investor by going for a patent and patenting your technologies, products, and your applications.
Yes. So all the soft knowledge and goodwill that plays a very significant part of the
Very
valuation.
true, sir.
And, yes, I
And
agree.
very importantly, your client base, your databases, your data analytics, data learning, your ML can be protected under the trade secret laws. So think of it and exploit more of a valuation.
Yes, and you are right. Actually, the trade secret or a secret sauce, that is one customer database, because the kind of customers you work with, the kind of machine learning or any work that you do inside, all these are very important assets. Yes, sir, you wanted to
Sir,
add something?
yeah, you had asked about the courses related to IP. Please go on the website of WIPO, World Intellectual Property Organization. There are hundreds of courses, and out of that, many of them are free of cost. And for students, whichever courses are there, paid courses, they are also at very cheap rate for students. So there are courses starting from maybe 3 hours to 6 months also. So you will learn a lot through those courses. Plus, there are many online PG diploma courses also, like Nalsar University, Indira Gandhi National Open University. Many universities have got 12 months diploma courses, PG diploma courses. You can go for those courses also. Thank you, sir.
Coming back to Ashna now, how a researcher can decide when to file multiple patents?
So, as I pointed out earlier, that sometimes as an inventor, you don't really understand that your invention probably has multiple patents to it. The rule is one novelty, one invention. So, probably unknowingly, you have invented more than a single invention. A couple of times that we've noticed is that lawyers themselves are able to identify that there are multiple inventions here, and depending on whether you wish to really work on the other aspects or what your monetary valuation of that invention is, we would advise that you file the most novel feature and then keep building on it to get multiple patents. Several times it also happens that you filed it, the application goes to examination, and you are slapped with an objection saying you have more than one invention, which sometimes works out very well because you get to file another patent right there and then as a divisional. You get time till this patent has finished prosecuting, which might be 1-2 years. So you have the time to think about it, get some money to back you up, and then file it. And you don't lose your priority date. So you're still blocking a lot of other competitors from, really blocking your invention out. So there are two major aspects you have to consider. One is whether you have the monetary value right now to file it right away. And two is where do you find yourself standing in terms of how well is that other aspect developed and whether it is ready to be put out. So divisionals are always a very good tool to rely on to not lose that date of priority and still keep getting multiple patents for that same invention.
I think Parag sir can explain you real life experience. He has filed multiple patents with single innovation.
Okay. Uh, uh, he has said it rightly. As I had told something related to prior art, when I was working with an MNC, uh, we have an IPR cell, and I used to send my patent application to them. They used to first evaluate, and after evaluation, if they find, then they used to approach to an attorney like ma'am, and then we used to file. Whenever I used to send an application, as I have said earlier, 99.9% of the time the application used to get rejected by them, by our own internal IPR cell. But while rejecting those patents, they used to say, those patentable ideas, they used to say, ki, nahi, there are this patent here which is covering this part of your invention. There is another, this patent which is covering this much part of your innovation. In other words, I'll say if I have got 10 claims, they'll give me 100 patents, and at least one claim is there in some of those patents, telling me that even if you go ahead to file the patent, you are unlikely to get the patent. This is where the real work of an innovator or an inventor starts. When everything is blocked, now there is no way out. That is where we start working. And in fact, what I should say, my body gets adrenaline dose the moment I see now you cannot get the patent. What I do is I study all those patents, and then I find certain gaps out of those patents, and I build over those gaps. Initially, I had sent one patent application which got rejected, saying that this is not possible. I have refined my invention after studying all those patents, and then my IP cell used to say, यार यहाँ तो 3-4 पेटेंट हो जाएंगे अब.
मिले भी है सर.
This is how my invention, which was earlier at this level, used to grow like this. And that is how I got multiple number of patents. So please study those patents, and then you can get multiple patents.
I'm going to share Parag sir's number. You can keep bothering him.
Yeah, no problem.
Yeah. So I think thank you for so now I think all three have shared their expertise and experiences. I would like to request the audience to, if there are any questions, to take. Yes, madam. Just introduce yourself and address the question to someone. So if you want to.
We'll take as many as questions.
I'm Dr. Pratibha Reddy. I'm assistant professor at GH Raisoni, Pune campus. So before going to ask my query, I just want to say proudly that I have 104 copyrights in my account. We 4 faculties have filed, and we received the grant of 99, and one day only we have filed 101 copyrights last
Great.
year. On the literary work, whatever we have done, we 4 professors included in that, and we have set a world record as well, like filing continuously.
Great. Congratulations.
Yeah, and my colleague Sarika ma'am, she is also one of the author in that literary work. So as sir said, even I have more love about patents, and like I want to do many things in the innovation and incubation related things. So sir, I just have a query. I have 5 patents in my account, but only one is granted and remaining under different stages. So I'm more confused about design patents actually. So design patents, as ma'am said and you said, like even in the safety pin you can do 200 plus patents are there, we can think of 201, but still if we are doing literature survey about the design patents, so many confusions are there, like especially in the clothing industry and all. So can you make more elaborate? Means I need clarity in that, like design patents exactly.
Okay. You want to understand the difference between utility patent and a design patent, right?
Product based and all, we have clear system and process, we are clear about it, but
Okay.
like more confusion about design patents, and I
Okay.
thought like it is like in daily life we are thinking more and more thoughts we have in the design patents, but we are not sure like can we go for patenting or not, and how much even we are studying related to that, but still I don't have much clarity about it.
Okay. Shall I answer, sir? Yeah. See, design patent is actually a word which is used in USA. In India, we only say design registration. And in USA, they have something called design patent and utility patent. In India, for utility patent, we only use the word patent. And for design patent, we use the word design registration. Now, utility patent is given for a product where you have added some novel functional feature which has started giving some more added value. Whereas a design registration happens purely on the aesthetics or ergonomic part of it. Like you might have seen different bottles of mineral water. All bottle do the same purpose of containing the water in it. But they are of different shapes, there are different colors. So these variations in these bottles most of the time will fall under design registration. But if you have made a bottle which maybe is little bit more durable, which even if it dropped from a particular height and it will not puncture or it will not spill over, then probably that bottle may fall under a utility patent. So another example I can give, we all have got mobiles, but each and every mobile looks little different. It has got different surfaces, cameras are positioned at different location. So all these features are design features, they are not utility patent features. But if you have a camera which is giving you something additional, maybe there was one invention where there used to be a pop-up camera, that could fall under utility patent. But otherwise all these changes in these mobiles are mostly they file under design registration. Another example, we see a lot of cars on the roads. All car has got one engine, one steering, four wheels and maybe four seats and all that, but their shapes are different, their colors are different, and probably their aerodynamics is also different. So as far as shapes and colors are concerned, it will all fall under design part. But if the aerodynamics is different and that changed aerodynamics gives you little more mileage, then it may fall under utility patent. I hope I have answered the question. And sir, would you like to add?
I think if you can do more of a prior art, try and find out close match to your innovation. If you can find 10 patents which are close to your match, then you can identify what you need to get patented, maybe utility or maybe design. Okay, more research needed.
Good afternoon, sir. It was nice listening to you. I'm Dr. Sunita Panikar from DYP College, Pimpri. I'm a microbiologist and I would like to know whether we can patent a microorganism. Like if I have isolated a microorganism giving a very good enzyme, then can I patent that organism or I'll have to go for patenting the enzyme itself?
I think it is a too technical question. You may need a domain expert. I will introduce you to the domain expert, so who will be able to answer you on this. We can take this separately, but you can find on stem cell bank. Lot of stem cell startups have come up and they have filed the patent, and I think you can also find patent. First hand I can answer yes, but let's have the opinion of a more domain expert in microbiology.
Thank you, sir.
Thank you.
Good afternoon, sir. I am Gaurav from GH Raisoni campus. Basically, we are in a prototype stage. So I want to know whether we can patent our idea or not. Because as you said, nowadays the first patent will be taken, not the first invention. So whether the idea can be patented or not.
Yeah. Now, this has got two answers. Yes and no both. Because the patent office doesn't want you to submit a prototype there. But what patent office wants is that your patent document should be so much in detail that anybody else should be able to practice that idea. Okay, in other words, he should be able to make a full-fledged working model of that your invention. Now, most of the time at idea stage, we are not very clear what we are doing until and unless we make maybe 2, 3, 4 or 10 prototypes. Our idea doesn't freeze up. So ideally, I'll suggest you make the prototype first. Now, if you're running out of time, you file a provisional application for the idea, but then you have got only 365 days left to complete the submit the complete specifications. Otherwise, you may lose the idea. So you have to take a judicious call. If you know that you will be able to complete that in 12 months time, then only you file it. Otherwise, keep it under carpet, work in a closed laboratory, complete your prototype. After that, you bring it to platform. Now, many a times, people prefer to submit on idea itself. And I have seen people we are good at creating the documents. I can create literally a very good document which will give an idea that I have made a prototype. But 99% of the time, that document may not be the perfect document. I may still get a patent. But then is my aim to get only a patent, or is my aim to protect a very good invention? Depends on that. I'll decide whether to go for the prototype or I'll go purely on paper.
Sir is sharing hack.
I would like to add a point to that. So usually, most times when someone comes to you at the prototype stage, where they're not really clear how it's going to work on paper, like Sir said, you can file a provisional, but that's not the end of it. If you've not finished your work in 12 months, file another provisional and claim priority to this one. A lot of times as lawyers, we tell you to just create a chain of priority, build on it, keep building. Because what a priority does is, it lets you hold on to that invention, but you can also say, I started from here and I added this. So build that chain, keep working on it. It's cheap to file a provisional application because you're only describing it, you're not claiming anything. So there's no claims. So you can have multiple provisional applications. So get that chain started. Don't be scared of getting it out there. As long as it makes logically sense on paper, put it in paper and speak to a lawyer.
Thank you, ma'am. Sir, my question is that if I have a product which is assembly of products available in the market, so we can say it that if I have a product with 5 products which are already patented, and I am doing the assembly of that product and making it a new product, so can I go for patent of that thing?
Actually, what question I wanted to ask is, you told about 2 different aspects, right? Like in India, we call it design report.
Design registration.
Yes, sorry, design registration. But in USA, we call it design patent.
Yeah.
So I just wanted to ask you one thing based upon this. If someone has filed a patent in USA, can I file it in India or not?
You can.
Okay.
In fact, you can file in all 200 countries also.
Okay. So everything.
But then
will be
there is
different,
a time frame within which you have to do it. You can't take 10 years. There is, I think, about 12
There
months
is an
time
agency
period.
in China doing this. Once you file the patent in India, in 3 months' time they file the same patent in China.
Yeah, that's
So
amazing.
Okay.
some great hacks.
But ideally, it should not get granted. That patent will not get granted ideally.
How will challenge the Chinese government?
Well, a lot of times, if it's falling under the period of within 12 months, you do have the right to take an early entry into other countries and file an application by claiming priority to it. So I think I'm being a little technical, but
Exactly.
if you have a year and you've realized that it's been filed today, speak to a lawyer. They'll be able to help you file in multiple countries.
I think what we will do is 5-6 people have questions. Maybe we will finish the session and you could answer them one-on-one. That would be helpful.
That will be good. Yes,
Just I'll answer in 1 minute his last question.
Yeah.
See, when you are saying you are assembling the parts together, see, by assembling, if you can make 1 + 1 equal to more than 2, you have a patent. If 1 + 1 equal to becomes 2, you do not have a patent.
Wow.
I hope I have answered your question.
Great.
So I think that was a very interesting reply. So I must thank Nilesh sir, Khedkar sir, and Ashna for your valuable insights. Actually, the patent word is please act today, not tomorrow. So whatever you want to do, start today. I mean, don't even wait for tomorrow. So with these words, I think we'll close this session. In case there are any questions, please talk to us, reach out to us. Research Park Foundation has the contact details, and we'll be happy to connect again.